There we go. Okay, recording is going. Hi, everybody. We are being recorded for the folk who can't be here and also just to have public record of this because public records. We're going to let other folk trickle in as we can. Hopefully we get it's definitely more than just this number who responded they were available right now. So, but hey, maybe Clackamas County had a bunch of civil commitments come in today, and they're all taken out. How's everybody doing this wonderful Monday morning?
Good. Kevin, I apologize for not letting you know sooner. The Dropbox is telling me I don't have access to the content.
Yeah, you're going to have to, there should be a button to request access. You are going to have to ask for that. We can't, we didn't have a way to whitelist people's accounts because who knows what all your accounts were going to be, or if you even had one. So,
okay.
Yeah, don't worry about it. I will say there's not a huge amount of material in there. I searched for what I could find from places, and there's some stuff on civil commitments, but there's not a whole ton as far as I could find on PCR or habeas standards, at least not in the qualifications realm. There's some performance standards that I could find, but qualifications seem to be a little harder to get a sense of where other jurisdictions have gone with that.
I imagine the lack of court-appointed counsel in other jurisdictions is a big issue because I don't know other jurisdictions that have a right to court-appointed counsel and habeas and post-conviction. So,
yeah, I wouldn't doubt that that's probably a big factor in whether there are standards. Okay. Oh, let me get the. That's up. Nope, we're going to do that. We're going to do it that way. Okay. I hate that it does that. There we go. Okay. Y'all can see the blank white sheet of paper that I've got up shared, right? Okay, cool. So here's kind of my thought on, hi, Joe, good to see you. Welcome. Just so you know, we are recording this for the folks who can't attend and also just to keep the record of the work group. Here's my thought. There's a lot that we could do with this, but I don't necessarily know what all that is or what it looks like. Jordan, likewise, has experience in some of the areas, but not others. What I was thinking we would do with our first group is get kind of a big picture sense of what areas we think need to be defined, and then maybe start working on specific standards within those areas, but really look at the outline of it's not dependency, it's not delinquency, it's not criminal, but we still do public defense in these areas, and get a sense of, are there ways we want to split things apart in current qualification standards? Do we want to collapse any of them, which I think is unlikely, but who knows, maybe. And are there things that we're missing? Are there just areas that we haven't considered, that there's stuff that goes on that we just haven't really put any standards together for? So this is really big open forum for everybody to bounce ideas and get a sense of what do we think the standards for all of the stuff that doesn't really classify. How should we deal with that? So to start off, does anybody have any questions or things they just want to get started with?
Well, it might be good to list out what we already have certifications for.
Yeah.
PCR, habeas, and civil commitments, I think, are the only three we have currently.
True. So civil commitment, we currently have one classification for civil commitment. We don't have any, that any type of civil commitment falls within this standard. There's PCR, which we have two levels for: PCR other and PCR murder. Do we have a PCR capital murder? The capital
don't
stuff
think
is
so.
all,
I think isn't there one for aggravated murder?
it might,
Appeals
Turn it
get
into-
split up that way anyway. I don't know about.
yeah. So
trial.
there might be, oops, oh, I said PRC, not PC. And I know, we treat anything capital or ag murder as slightly different. Like, it's not the normal qualification process that our team handles. So that may be a piece that has historically just been kept separate, but we're going to want to combine, like, all of the standards. We're definitely going to want to make sure that we're putting together, that we've got adequately defined across. So then we've got habeas. Currently only one standard for habeas. I don't know if there's subject, like, I know medical habeas is a thing, but I don't know if it's defined enough as different from other that it matters to have, like, is it a specialized practice that you need something like specialized knowledge in, or do we want to keep everything? Okay, cool. Thanks, Jordan. And then we do have contempt. Currently, the standards for contempt are contained in the same standards as criminal misdemeanor, given that they use different procedural codes. We're looking at splitting that out. It used to be that we had two boxes in our database for it. We collapsed those because it turns out you qualify for one and it's the exact same thing. So, okay. Am I missing anything, Jordan? I don't know. I moved adoption over into the dependency group.
Not that we currently have, no.
The one thing I can think of that we don't currently have any standards for, and we didn't actually recruit anybody for the work group for, is mandamus. But there's like 2 people who regularly do that. I'm not 100% sure whether I'm going to throw it in here just as something to keep our minds on. But I don't know that there's enough going on with this that we need to create a standard at the time. But Meg, did you have something you wanted to add? Okay.
Kevin, I'd also add, and we talked about this a little bit in the criminal group, support enforcement dockets, child support.
So we always call them non-support.
Yeah.
Support enforcement makes sense too. Okay. Does anybody think that some of these need to be split out or combined?
I think maybe for habeas, like you were saying, because there are the like authority for confinement cases and then conditions of confinement and deprivation of rights. And those are pretty different. Like authority for confinement is much more like direct appeal or PCR kind of similar to those kinds of issues. And then conditions of confinement is a lot of medical care, and you're dealing with like medical records, medical experts. It's much more like a little mini trial, like civil rights kind of trial. And those just, yeah, I guess those seem pretty different. I don't know that they have to be like different standards necessarily. Like the authority for confinement stuff probably would just get covered by some, I don't know. Yeah. Those are my thoughts.
So in theory, somebody who was qualified for conditions of confinement would likely also qualify for authority of confinement? but
Yeah,
the reverse
yeah,
would be the
but I
same?
don't know that you wouldn't need all of the like conditions of confinement qualifications to do authority of confinement.
No, but that could be like a progression that we could create within the habeas like system is your first few, you're going to be handling authority for confinement, or you may be limited to those kinds. You're certified for that level. And then if, for instance, you know, historically civil commitment has needed lesser felony, at least criminal certification in order to handle them. You need that plus a lot of work dealing with medical experts to be able to handle civil commitment. Maybe that's something similar that we're doing here. Joe.
Yeah, so I would even, I'm agreeing with what everybody is saying, just in terms of thinking about habeas, but just in terms of degree of complexity, I think it sounds like what's been said so far is that conditions of confinement is going to be more complex than just a authority for confinement. I would note also that there may be some additional complexity within just the authority for confinement. When somebody is filing a habeas petition to challenge an extradition, the number of issues that can be addressed in those are very, very limited. And I would even say that would even be sort of a lesser standard for authority of confinement.
Okay, so there's gradations within this. Are they substantial enough? So like extradition is limited. And then others are more complicated, more complicated, more complex.
I think so.
Okay.
I would just say that like authority for confinement and conditions of confinement are dealing with like dramatically different kinds of issues. So I don't know that it's a like progression necessarily.
Okay.
Yeah, I think there are probably people that would be interested in doing authority of confinement that might not be good for conditions of confinement and vice versa. Maybe not, but like, yeah, I think they're pretty different.
Okay.
That's all.
And who
looks
who
like we
joined
had-
us by? Sorry, go ahead.
You're on
it. Who joined us by phone?
Bailey.
Oh, Bailey. Good. Okay.
Hey, Bailey.
Thanks for joining. Just so that you're aware, since you can't see the flag, we are recording this. Okay. So, but Meg, to your. Oh, I'm sorry, Becca. You've had your hand up. Go ahead.
Oh, you can finish the habeas stuff first. I was just thinking about some other issues. You can come back.
Okay. But what it sounds like, Meg, that you and I think Joe are both kind of in agreement with at the very least is that authority and conditions are substantially different enough that it might be worth having different qualification standards. And then whether we consider them to have a hierarchy is maybe a later question. But at the moment, we can create what would we want somebody who is qualified to handle these independently. What would we want them to be able to demonstrate in order to be certified for that? Okay. Okay. Becca, go ahead.
I would just say that on the civil commitment, I think it is a progression between the regular civil commitment and then the extremely dangerous person or the 701 commitments, that there should be a step up. And then I would just suggest that the SED stuff could go into the regular contempt.
You think that they're similar enough to just go ahead and collapse them into one type?
I think so.
Okay. We don't currently break them out. I've got this here just as kind of a loose seeing where we're going with things. Okay. I keep up with a fair amount of civil commitment stuff, but I have to admit that I have not been super. I know that there was some legislation around developmental disability commitments recently. Is Chapter 427 no longer a thing, or is that?
It is still a thing.
It is still a thing. Okay. So I don't know if everybody's had a chance to look through the materials in the Dropbox. I know that you do have to request access. I don't know if everybody's actually been able to get that access. Montana has those two forms, the mental health disorder and the developmental disability, split out as separate qualifications. I will say they're really, really generic, vague qualifications for each. So I'm not sure that it mattered for theirs to split them out, but is that something we would want to do here as well and have explicitly separate qualification standards for mental health, developmental disability, and then extremely dangerous person as a higher level, more complex, more difficult commitment standard? Or would we want the mental health and developmental disability combined? Like, I don't know much about the procedural structure for developmental disability commitments. Is it the same as a mental health commitment, or is it different? I know the EDP procedures are different.
This is Bailey, the 427. Oh, sorry, someone else can go.
I think, go ahead,
I thought
Bailey.
I heard someone else talking. Thank you.
No, go ahead.
427 does have its own chapter procedures. That being said, my position on that is it's pretty functionally similar to 426. There's just some differences. If we were to make separate qualifications, then it would just be separate qualifications showing they understand the differences between 426 and 427, because where they do differ can be pretty drastic.
I agree with Bailey. I think the qualification standards can be the same. I don't know if this is part of this conversation, but I think part of the qualification standards should be some required training, and the training can sort of deal with the differences in the 427 and 426 statute, and also with some of the differences in working with clients that have intellectual or developmental disability versus working with clients that have psychiatric disabilities.
Okay. And we'll get more, I think it may be that we nail out a good rough outline of this today early, and we can start working into the individual, like, what do we want to see pieces in these qualifications? But before we get into that part, I do want to have us get the broad overview and make sure that we're not missing anything first. But okay, cool. But what I'm hearing is the mental health and developmental disability can be the same qualification standard, but to meet that, you have to have some training on what are the differences between these two procedural codes. And substantively, how do these clients differ so that you can most effectively represent them. To some degree, some of that may be part of the next phase. Like, we will develop the qualification standards here, and then there's another phase coming later where we talk about the performance standards, and we can reference those performance standards in the qualification standards, even though we haven't written them yet. We'll just say, this is where, to look to, or be familiar with this if necessary, as appropriate. Okay, let me put, so we've got PCR is 3. And then, okay. Were there any other comments on the structure for civil commitment before we move on?
This is Bailey again. I don't know if anyone proposed anything yet regarding the extremely dangerous, but there should be a higher standard, I think, for qualification for extremely dangerous.
Yeah, I think that's one thing that we have relatively recently recognized as a big gap in our qualification structures as it currently stands. And we are planning to coordinate with the criminal standards work group, because the everything EDP is such a mix between criminal and civil commitment. So, okay. All right. Let's, it was talked about potentially moving contempt, the support enforcement into contempt. I've done a number of support enforcement stuff. I kind of agree that it's not a hugely different. Is there merit? I know it's relatively rare. Is there merit to the civil case punitive contempt being something that we need to pull out of this? Since you do get, even in a civil case, if somebody's asking for incarceration as a penalty, you have a right to a public defense attorney on those. And this is just like, it's an area that I know very little about.
I'd say no.
No? Okay. So does everybody feel comfortable collapsing everything contempt related into a single qualification standard? Okay, cool. And does anybody here have mandamus experience? Because I don't want to worry too much about this if we don't.
Kevin, I did one petition in a habeas case. I think if Laura still is the main go-to, I know she's the person I talked to, but I did one petition in a habeas case a few years ago that was not granted, and I like doing that kind of work, but that's the extent of my experience here in Oregon.
Yeah, okay. And it may be that, it may be that that's beyond the scope of our work group for this process, but we'll check on that and maybe come back in the next one. Okay. What are we missing?
Did we discuss PSRB?
We did not. We did not, and that's okay. So let's throw PSRB. Bailey, are there gradations to PSRB practice that we would want to account for in a hierarchy?
No, I don't think so. I think Allison also does PSRB representation.
I think there's a corollary of the EDP commitments that also translates over into PSRB representation. But I think PSRB can be its own heading. I don't think we need to separate that out.
Okay. So are they procedurally or substantively different enough that they need okay. So we can just leave that as one. Oops.
Absolutely.
Okay. Okay. What else are we missing? I think.
Let's see. I don't know if it's appropriate for this work group. It may be more appropriate in the criminal, but are there standards for helping a client through an aid and assist process when they're charged with a crime? Because it's kind of a big and sort of omnipresent system right now.
I think that needs to come from the criminal work group, that the aid and assist part is entirely part of the criminal process. So the criminal lawyers, there needs to be standards for, I think that should be part of their conversation, definitely. But it's not going to be separated out in the way that commitment is separated out.
Okay.
Are we treatment court? Are we covering treatment court standards?
That's a good question. I know that some states have standards that explicitly break treatment court work out from the normal the rest of like criminal standards. I don't know that one of the issues that we have is that we have treatment courts that cross all of the other, like there's dependency treatment courts, delinquency treatment courts, and criminal treatment courts. But I don't know that that's something that means it's in our sphere or that needs to be pulled out. Jordan, I don't know what criminal group is doing with regards to treatment courts.
I doubt we're going to get there in this revision.
Okay. Allison, what are your thoughts on this?
Oh, I think that's fine. I just didn't, I wanted to make sure that we were covering everything we were supposed to cover.
Okay. We weren't explicitly looking at covering treatment courts as something separate from the normal criminal process. I think much like aid and assist docket, more just making sure that, well, maybe that'll be something more practice standards oriented than necessarily qualification standards, since the way you work with a client is different in that sphere. Okay. What questions do folk have about the outline that we have so far? Does this feel like a solid split of different topics? We've got some hierarchy where it's appropriate. How are people feeling on that front? Okay, cool.
Sorry, it just occurred to me, this is also related to criminal, but I'm not sure that it would be covered by the criminal, but material witness, representing a material witness.
Oh, that's a good question. I'm going to throw that in here. I think that's not a terrible idea for us to have. Well, let's just call it material witness. That is something that I think may be a little more difficult for us to define, especially since the standards for when somebody is entitled to court-appointed counsel on that is a little wonky. So we'll that may be something we want to make sure is in our sphere before we devote too much time to it. But it's a good thought to make sure that we're catching things like that. Excuse me. Okay. Anything else that we feel like we want or need to add to this outline before we start diving into particulars? Okay, I'll take that silence as we're good. So let's, where do folks want to start with respect to, we've got a bunch of different topics here that we can pick from. Where do folks want to start with putting down some, what do we think attorneys should be able to demonstrate in order to, and to bring things to, let's see, I'm going to pull up the current standards. I only put these in as like a reference to what exists right now. We are not beholden to maintain structure or content with respect to any of the current standards as they are. Ed, go ahead.
So PCR and habeas are my areas. So others can add in as far as civil commitment and PSRB, but with habeas and PCR, you're dealing almost entirely with rules of civil procedure. And most criminal practitioners just, whether it's actually drafting a pleading that comports with the rules or actually just litigating, that's something that really, to be effective, you can't just come from criminal practice and think you can do that. So I think certainly PCR and habeas, we want to address understanding how to litigate under civil rules, pleading and litigation. And then if that applies to civil commitment, PSRB, or, on contempt and the others, that to me as a practitioner are the, the biggest areas and biggest issues that you'll need to understand.
Okay. I'm going to go ahead and throw that in. Yeah, okay. I'm going to throw that into the habeas stuff as well. So I'm going to put that above the hierarchy as a fundamental component. I figure we've got a really solid hierarchy for PCR. I'm a little unclear about whether we're going to retain a hierarchy for habeas. So I'm just going to set this is applicable to all habeas. And then we can decide how to restructure that as necessary.
And on that topic, those are, I mean, that much of that isn't necessarily substantive, it's procedural. So it should be, I think it's a good skill to have, but
yeah. Okay. Are there other, I think contempt that probably fits in as well. My wife at one point did a civil civil contempt, punitive sanction representation, and used the civil procedure to great effect in that one. So I'm going to throw that in. Okay. What else would this generally fall under? Does it apply? Does this apply to PSRB? Do we use the rules of civil procedure in PSRB filings and hearings?
Administrative law.
Okay, so it's purely administrative. Okay.
Yep, no rules of evidence.
So let's put does that feel, is that the right way to say it, that you'd need an understanding of the PSRB's administrative rules?
And also just how administrative law functions generally. So like when you can appeal to the Court of Appeals, what is the standard at the Court of Appeals, given that it's an administrative proceeding? I think there are some constitutional issues. Like I think mandamus is potentially available too as well. So understanding how those things interact.
Okay. Okay. And then I don't know that I had a lot of time to dive into the what procedural code civil commitments were under, just kind of used what I understood was available to me. How does this interact with civil commitments?
The rules of evidence apply to the hearing. The timeline on a civil commitment is so quickly that
Yeah.
I think technically the rules of civil procedure would apply, although I'd be interested to hear what Bailey has to say about that, but we're not like filing meetings or anything like that. So
yeah, a lot of the time the rules of civil procedure are avoided. Part of that is because the DA's office doesn't know the rules of civil procedure. Part of that is we don't have time to comply with things like filing requirements, like what Allison said. So, but a lot of the procedure is also laid out in each statutory scheme itself.
yeah.
So is this something that we feel the need to comment on, or is it something that we want to leave silent?
I'm not sure.
I don't think we need to comment on that. Again, I think like that what we're discussing probably was best gone in a training or when we're talking about the kinds of things that people need to be proficient at in order to do civil commitment hearings.
So to give you guys an idea of where some of the talk that we're having internally about this is, we're trying to move more towards skill-oriented qualifications. These are the skills that you would need to demonstrate. How you achieve and how you demonstrate those skills might come from different sources. We are contemplating having training, like certifying trainings that other people put on, or having our own trainings, contracting specifically to have people do trainings, things in those range where we might have, say, okay, we'll certify that certain trainings provide training in these skills, and that will demonstrate to us that you've met these particular qualifications, if that makes sense. So yeah, I totally get where you're going, Allison, and this might be something where we just need to show that there is that if you've done a training on this subject, you've passed this particular portion of the qualification. So
are you asking for what like are you asking for like us to comment on all of those subject areas, or are you just talking about the procedural subject area right now?
Right. I mean, I'm kind of following where everybody's kind of been talking so far. We were having good discussion on procedure, so that's kind of where I just wanted to nail that out first. But we can go wherever and hit whichever topics make sense to folk. Right now, I think being general is good. We'll then refine some things internally. We'll put together a draft and then we'll come back and look at how to tweak things and where do we want things to be more specific? Where do we want them to be more general? If that makes sense.
Well, I think procedurally, people need to have an understanding of the rules of evidence, particularly related to expert testimony in the rules of evidence and privileges in the rules of evidence. And people need to have some degree of skill, or at least be supervised while they're developing skills in litigation, generally speaking. So you're going to have to do a lot of cross-examination in a civil commitment hearing.
Is this something that we want to say someone has handled other types of cases with expert testimony before, or can it be?
I mean, I don't know that it helps necessarily to have like cross-examined a toxicologist. I think that's, and this is, I think, a different conversation, but like right now, the baseline is you have to be minimum felony qualified in order to be civil commitment qualified. I don't know that that is necessarily helpful. Just like being able to try felony cases, I don't think necessarily means that you can competently try civil commitment cases. But I think having some facility with litigation, and like this is judge advocacy, it's not jury advocacy. So that you've tried a felony to a jury like doesn't really have anything to do with whether you would be effective at civil commitment. So I think
so let's say if I shorten this to just having experience in litigation, bench oriented, just to kind of capture like short form, what you're trying to put in here. To give you an idea of what I don't know if, I don't know if everyone has read the current qualification standards for civil commitments recently. It is lesser felony criminal qualification, has handled at least 3 civil, juvenile, or criminal cases in which a psychiatric or psychological expert was consulted by the attorney and the use of that evidence was discussed with the client, has knowledge of available alternatives to institutional commitment, has knowledge of the statutes, case law, standards, and procedures relating to involuntary commitment, and satisfies one of the following, has either co-counseled 2 civil commitment cases that have been submitted to the judge, or observed 5 civil commitment hearings. So
yeah, I think the specific experience in civil commitment matters more than having dealt with a psychological expert in a criminal case. I think like I think you should have some foundational mental health knowledge or some foundational psychiatric knowledge, however we want to describe that. But I don't know that advising a client on aid and assist is necessarily a relevant crossover skill in being able to litigate a civil commitment.
Right, I agree with that, because aid and assist isn't a decision that our client gets to make. It's not like an argument we can make in a civil commitment hearing, like, oh, they're unable to aid and assist, so that's what needs to happen. Like, no, people get committed who are unable to aid and assist all the time. Right. I do think there would be merit to requiring minor felony qualification might even be a little bit low for EDP civil commitment, because I do think that it's helpful to have an understanding of felony sentencing when someone is facing EDP commitment, because that's someone who very likely has both Measure 11 charges and a pending EDP, and having a working knowledge of that I think is important. But I agree with Allison that I don't think the felony qualification is necessary for 426 or 427.
I totally agree with that. I think for EDP commitments, people need to be major felony qualified. It requires a bench trial essentially on a major felony.
And I think to also piggyback off of the requirement of having knowledge of psychiatric illnesses is also to be able to distinguish psychiatric from biological, intellectual disability, developmental disabilities, and be knowledgeable enough about the differences to be able to distinguish those, because sometimes that's a defense if they filed the wrong petition, for example. And being able to articulate those differences is important. And having familiarity with what it takes to get someone diagnosed with intellectual disability, I think, is really important, because we're getting a ton of materials in these hearings that is all about adaptive assessments and things like that. And being able to demonstrate familiarity with and understanding of those materials, I think, is crucial.
Sorry, can you repeat what materials you're meaning?
Typically, in like an intellectual disability, we're getting not just a psych eval detailing the intellectual disability, but sometimes like adaptive assessments. And for people in stabilization and crisis unit, there's things like positive behavior support plans and functional behavior assessments, which I think functions as an adaptive assessment. All of those things I think are important for someone to be able to parse and interpret and make commentary on, essentially, as to how it impacts that person's committability under
Gotcha.
the 427 civil commitment.
Okay. Jordan.
Those are all pretty standardized.
Okay, thanks, Bailey.
Thanks, Kevin. To bounce back to the EDP commitment stuff, just to tie in with the criminal group, one of the things we're talking about is pretty drastically revising the way the qualifications are split out. So it may be helpful to talk more about what we mean by the type of felony that we want experience in, rather than the broad category that's currently major felonies. Those are probably going to get shifted to be felony and Measure 11. So felony on one hand and Measure 11 sex offense cases on Measure 11 and sex offense cases as a higher categorization, just because we all kind of agreed that there's a pretty humongous difference between like a driving while suspended felony and like a rape 1 felony, even though both of those are currently major felonies right now. So
the felonies that qualify for an EDP commitment are the first degree Measure 11 crimes. So we say Measure 11 qualified under that standard then.
I would say
They are trying to. Oh, go ahead.
No, you go ahead.
I wanted to say, Marion County DA's office is pushing, I think, in the next legislative session for attempted Measure 11 offenses to be included in EDP, and so I don't know how far in advance we want to be prepared for that, because that is technically then not Measure 11.
But I think if we just said Measure 11, though, that would also encapsulate attempted Measure 11s, just in terms of the kinds of defenses that you could raise at the like fact-finding stage. If you're Measure 11 qualified, then you're also Measure 11 qualified.
Right. Yeah, that's true.
Okay. Somebody else. Maybe Allison. Oh no, Joe, you're up, I think.
So thanks. I have 2 issues just in terms of the first, in terms of the EDP commitment.
Mhm.
I don't know if I'm aware of one of those that's not been on the tail of timing a person who's charged with a major felony, usually Measure 11, then timing out on the aid and assist timeline. That seems to be the most common. I don't know if it should be considered here, but it really should be the attorney that represented the person in the criminal matter that represents the person in the EDP, just for continuity of representation, as well as familiarity with the client and the facts already, is my first thought. I'm not sure if we can accomplish that through these rules. It's just a thought. The other thing that this is returning to, just sort of the current standards for civil commitments as they exist. it's already been commented, and I agree how insanely fast civil commitment cases go. I think that some thought should be given to the need to have watched 5 or to have co-chaired 2. I think that is going to limit the availability of people who are going to actually be qualified under those standards, particularly in jurisdictions where civil commitments happen so infrequently. I know they happen a lot in Marion County, they happen a lot in Multnomah County, but even in Washington County, I understand that they're not super frequent. And so just a thought.
I think a civil commitment is so unique that some type of direct exposure to a commitment hearing is really necessary in order for a person to be qualified. And a lot of civil commitment hearings post-COVID, maybe most jurisdictions are doing some degree of virtual hybrid commitment. So observing a civil commitment hearing, even if you're in Umatilla County, we can make it so that you can observe a hearing in Marion County or in Lane County or whatever. But I think that co-counseling requirement is really important.
So let me see if I can find the document and which one was it? Washington. Washington requires your first civil commitment hearing be supervised. And they also require, in general, that you have 1 year of experience as a prosecutor, public defense provider, or private civil commitment attorney, and that you have observed at least 5 civil commitment proceedings. I don't disagree that we want somebody handling these independent. Remember, the minimum qualification standards is these are the minimum things that we would want somebody to have, some minimum amounts of experience we'd want somebody to have to be able to pick up a case and handle it not without any oversight at all, but like we would expect, okay, you're competent to go in and handle this on your own. So what I've put in from that brief discussion is observation or co-counsel of a minimum of X civil commitment hearings submitted to a judge. Allison, I think go ahead.
I think 5 is reasonable. I think we have to make sure that some of that has been 426 commitment and some of that has been 427 commitment. I don't know that you need a year of experience before you start co-counseling civil commitment hearings. And maybe if you have more experience overall, you don't need as many co-counsels, but I think you need to have been exposed to a few of both types of 426 and 427 commitments to really get a handle on because some commitment hearings, there isn't very much for you to, you're objecting when you need to object and making sure that the procedure is followed and protecting your client's dignity. But that type of a commitment is vastly different than the type of commitment where you are really arguing, like maybe calling your own experts, calling your own witnesses, making like real arguments about not committing somebody. So ideally, you'll have seen both types of those hearings.
Okay. Becca, are you in comment to this, or were you going to lead us on something else?
No, in comment to this.
Good.
But actually looping back to the EDP commitment, I have some reservations about making a felony qualified, much less Measure 11 qualified, to do the EDP commitments. And it's also, I think, an area where there has to be some overlap contemplated, because in a lot of counties, there's totally different people who are handling the commitment versus criminal cases. And so if, like in Washington County, the court has been willing to take it away from an attorney who's had it, for years a case and dump it into a civil commitment attorney because they are civil commitment qualified, whereas that person doesn't know anything about the underlying facts of like the murder charge or whatever. I don't know. I don't know that we need to put all of our minimum qualifications in one person for those. I think it's a great area where you're gonna have a criminal attorney who's been working on that case almost always, but may not have the civil commitment experience. So it's a place where those two attorneys together ideally should do it. Just a thought, because I think either one could do a disservice to client, whether it's somebody who's done civil commitments but is not major felony qualified, or vice versa. A lot of, major felony attorneys don't do any civil commitments. So just a thought.
I think having two lawyers on it is a good idea, although I don't like just a standard 426 civil commitment lawyer. I'm not sure adds much to an EDP commitment. I think it needs to be a commitment practitioner who also has criminal experience, or maybe if we have special qualifications for EDP civil commitment, but just the statutes are so different and what we're dealing with is so different that I don't know that just doing 426 commitments makes you qualified to do EDP commitments, even though I know that that's what the standard says.
Yeah,
but
I agree.
Yeah, I think I think that's a good point, that the total needed qualifications can exist in two different lawyers, but I don't know that it's necessarily a Measure 11 lawyer and a regular civil commitment lawyer that encapsulates that.
Let's because we have the ideal, the world we want, and we have the world that we live in, which is judges may say, yeah, I'm going to take this from you and hand it to somebody else. And we can fight that as much as we want, but sometimes that fight doesn't go well or doesn't go how we would want. So we can write this in a way that allows people to handle them individually or on a co-counsel, I think. What would we minimum want somebody who's handling EDP to have if they are co-counsel? Let's start with that. And then we can say, if you're going to be handling this independently, you've got to have these additional pieces.
Well, I think it depends on which position of the co-counsel you're talking about. I think if we're talking about I think at least one lawyer on the team needs to be Measure 11 qualified, I would say. I don't know that it needs to be both, but at least one lawyer on the team needs to be Measure 11 qualified.
Okay.
I would also say that sorry, go ahead, Allison.
No, go ahead.
I was going to say, in terms of co-counsel, they should have many of the, 1, 2, 3 of at least of the mental health or developmental disability qualifications of the ordinary civil commitment. Not necessarily.
Sorry, go ahead, Jeff.
I was going to say, I don't necessarily think they need to have observed the procedural aspects, number 4 of the civil commitments, because the procedure is going to be different for an extremely dangerous person than it is for an ordinary civil commitment.
So the way I've contemplated this is that we have EDP commitment as a higher qualification in the civil commitment sphere. And I'm writing these as anything we put into the EDP is in addition to the base level civil commitment practice. For one thing, I see what you're talking about now with which attorney are we talking about as co-counsel?
I think makes sense. I mean, if we're thinking about, so one civil commitment lawyer, one Major 11 lawyer, but the civil commitment lawyer also needs to have additional experience in the consequences of an EDP hearing and kind of the realities of the PSRB, which the regular civil commitment lawyers don't need to know about.
Okay.
Are we talking about developing separate standards for EDP counsel and EDP co-counsel, and then like a first chair and second chair situation? I'm getting confused.
Yeah, well, so, I mean, the long and short of it is, as long as we all work together within the work group and with the criminal work group, we can define whatever structure we want. I mean, we're gonna have to workshop that internally as well to make sure it's something that we can reasonably facilitate. Like, that is kind of the other side of this, is that the agency is gonna have to be able to put this into practice. And so there may be some retooling that we need to do to make sure that that works. But ultimately, we can choose the structure that we want to create that makes the most sense for this practice.
I think having
That does make sense.
Go ahead, Bailey.
No, you go ahead also.
I think having the criminal lawyer remain, like as long as that was a good relationship, or as long as they're comfortable doing that, makes a lot of sense. So if we think about EDP commitment sort of as adding the commitment qualified attorney to the team to make sure that the sort of penalty phase, if you will, of the EDP hearing is accounted for appropriately.
Yeah, I agree with that. I'm not sure if like the intent is to incorporate like, well, I guess no. I guess they can just both be co-counsel, and then the EDP attorney is the one that's primarily handling like the ins and outs of the actual hearing, but should regardless be someone who has a functional understanding of the felony structure, sentencing guidelines, other alternatives.
Okay,
Maybe-
so would that be covered by having the one or the other count? Like, if you're co-counsel, then the other person needs to be qualified to handle Measure 11s. And if you're doing it on your own, you need to be qualified to handle Measure 11s.
There
Okay.
are going to be circumstances where it's not going to be a Measure 11 case, and so there's not already going to be a Measure 11 attorney on it. I had one that came out of a non-Measure 11. Actually, my first EDP petition I ever had was out of a non-Measure 11 case.
Okay.
What was the charge that they were?
It was attempted rape in the first degree, but there was another incident that had happened literally 10 years prior that they were relying upon. That would have been Measure 11 had they been able to prosecute it.
But I think even in that scenario, it's still, there's a fact finding component to it that you can raise defenses to in the same way that you would in a Measure 11 hearing. So I think having a Measure 11 qualified attorney is still necessary.
Right. So
I agree, and that's where I think the EDP counsel should be Measure 11 qualified.
Yeah.
Regardless of whether co-counsel is the EDP. Okay. So, okay, maybe I can rewrite this one. At least one attorney for client is certified to measure 11. Okay. Because what I think what Bailey is bringing up is here's a hole in our qualifications, because if the other attorney is only major felon or is only felony qualified in the new system or whatever it's called, if they're not measure 11 qualified and neither is EDP counsel, now we've got a problem. So we
Yeah.
got to write it in such a way that at least somebody's hitting that. Okay. Okay, cool. What else or what is there anything else that we want to put in for EDP that's, oh, you know what? I apologize. It's new. we've used our hour. So what do folk want to do? I can take this. We can work a little bit longer if we'd like, if people are available. I can take this and we can workshop it internally for a little bit, and we can. I'll send out a doodle poll for our next meeting, and we can further assess this when we come back. Let's take a quick vote. How do people want to proceed right now? And Allison, I see your, there's more comments in there. I see your comment about the ethical rules. I think we're probably going to refer to performance standards. Because that would be more specific than necessarily the ethical rule. The performance standards would then reference the ethical rules. That's where we would base them off of.
Right. I'm just saying that those particular ethical rules for representing a client with diminished capacity, which it's like we should all be familiar with the ethical rules all the time, sure. But what Bailey was saying previously, your client in a civil commitment hearing most of the time is going to be unable to aid and assist in the criminal context. So being familiar with how do you represent a client with diminished capacity ethically is important for that representation.
Good note. I'm going to put that in the base level. Does that feel like the appropriate place? I assume it's per. Yeah. Okay. Cool. All right. Quick vote. Raise of hand if you can. Do you want to stick around for maybe another 15 minutes? Okay, that's definitely okay. All right, we've got some hands raised. I don't think we've got a majority though, so I'm going to say let's go ahead and end for today here. We've got a good outline for the bulk of the for the breadth of what we want. We're starting to work on specifics. We can come back and work more specifics at our next meeting. Thank you, everybody. I will put a copy of the current direct, like these notes. We will pull a transcript from the recording and add that those to the Dropbox as well. And when I get a draft of the qualification standards put together, I will add that to the Dropbox. Okay. I appreciate everybody. Yeah, go ahead, Meg.
Right, just a quick question about the Dropbox. I got access and the only folder I see is criminal with a resources folder in it and then some of the documents from the criminal group. Is that the right Dropbox?
You should have access to the whole project Dropbox. So I will try and send out it's possible I sent the wrong link, so I will send another link. Make sure that you should have access to, I think it's called Public Defense Standards Development, and then there should be multiple folders inside that, one for Quasi-Criminal, which is where we're throwing all of our stuff in.
Okay.
So, okay, cool. I will go ahead and put all those things into the Dropbox once they're ready. Thank you, everybody. I will send a doodle poll with an updated link and later today, and we'll schedule our next session. I appreciate everybody's involvement and time. Thank you very much. This has been a great discussion.